Hello everybody, Andrew Reed here, and we're going to jump into part 5 of my NCA exam study guide for constitutional law. And this part is going to cover peace, order, and good government. So I'm just going along with the syllabus and creating notes and or case briefs through the hyperlinks in the syllabus. And this is part 5 of this particular series. Peace, order, and good government. This is in the section 91 of the Constitution. This is where if there's a matter of national concern, then even if it doesn't fall under the heads of powers, the Parliament can still make it law. And so we have section 91. We're going to go ahead and dive right in. Section 91 says, "It shall be lawful for the Queen, by and with the advice and consent of the Senate and House of Commons, to make laws for the peace, order, and good government of Canada, regardless if it falls under the heads of power." So let's take a look. They have two cases highlighted here that take a look into peace, order, and good government. Okay, so the Anti-Inflation Act of 1976. This was passed in 1975, retroactive effect, and it was to provide for the restraint of profit margins, prices, dividends in Canada, basically to regulate trade, stock market, things like that, and to regulate the economy itself, and to reduce inflation, which the Parliament had regarded as against the interest of all Canadians. So such containment and reduction of inflation was recognized by the Parliament of Canada as a matter of serious national concern. So this act provided for the governor guidelines to restrain, control prices, profit margins, price control, compensation of employees, amounts of dividends. And so the question when this came before the court here was whether it was ultra vires for the Parliament of Canada, either in whole or in part, and if so, how much. In the second issue, there was a second agreement between the government of Canada and the government of Ontario, and was that effective under the Anti-Inflation Act, if it was intra vires, so valid. And the rule they came up with here is that if it is such that it goes beyond local or provincial concern or interest and must from its inherent nature be the concern of the country as a whole, then it will fall within the competence of Parliament as a matter affecting POG, Peace, Order, Good Government, Canada. Though it may in another aspect touch on matters specifically reserved to the provincial legislators in Section 92 of the Constitution. And this is from the case of Russell v. the Queen. So the conclusion was that, no, this was a valid act, and this agreement was therefore valid as well. But it was not effective to render this act binding on the Ontario public sector, even though it was valid. Interesting. Okay, so the analysis they came up with, this is Judge Laskin and his and people in agreement with him, said the Anti-Inflation Act was the valid legislation for the POG of Canada. It was temporarily necessary to meet a situation of economic crisis, imperiling the well-being of the people of Canada as a whole, and it required Parliament's intervention in the interest of the country as a whole. In enacting this act as a measure for POG, they weren't opening an area of authority that would have otherwise had no anchorage, but rather it is proceeding from legislative power bases which entitle it to wage war on inflation through monetary and fiscal policies, and to entitle it to embrace within this act some of the sectors covered, but not all. And I believe this was in concurrence. Judges Marlin, Ritchie, and Pigeon say whether or not the Anti-Inflation Act is ultra vires must depend on whether or not the legislation was enacted to combat a national economic emergency, where there can be said to be an urgent and critical situation affecting all Canadians, presenting as an emergency which only can be effectively dealt with by Parliament in exercise of the power of Section 91, in this case the Constitution, to make laws for the peace, order, and government of Canada. However, the authority of Parliament in this regard is limited to dealing with critical conditions and the necessity to which they give rise, and must be confined to a legislation of a temporary character. There was some dissent on this holding for Beats and Grand Pré. They say the Anti-Inflation Act and the guidelines thereunder directly and ostensibly interfere with classes of matters which have been invariably been held to come under provincial jurisdiction exclusively, property and civil rights, and the law of contract, so that On its face, this act is ultimately not constitutional. There's nothing in the Anti-Inflation Act or the guidelines to show they've been passed to deal with an actual national emergency. So they were the minority, so it was held to be constitutional, despite that strong dissent. Another case with a strong dissent, and the second one, hyperlinked under the POG section of the syllabus for the NCA exam, is references Greenhouse Gas Pollution Pricing Act. So the big issue in this case, which was whether this greenhouse gas pricing, this national regulation establishing a greenhouse gas price, was a matter of national concern falling within Parliament's power to legislate in respect of POG. So the rule that actually comes from this case, and then they're pulling from other cases, they're saying that finding that a matter is of national concern involves a three-step analysis. First, the threshold question. Canada must establish that the matter is of sufficient concern to the country as a whole to warrant consideration as a possible matter of national concern. Second, this matter must have a singleness, distinctiveness, and indivisibility. Third, Canada must show that the proposed matter has a scale of impact on provincial jurisdiction that is reconcilable with the division of powers. So the purpose of the national concern analysis is to identify matters of major national concern inherently, matters which by their nature transcend the provinces, which have grave extra-provincial consequences, to quote. So the analysis here, and this is a lengthy one, and this is from the, so they did hold this to be constitutional, and this is from the majority here. They're saying the focus of this act is on the national greenhouse gas pricing. So in Parliament's eyes, the mischief is the effects of the failures of some provinces to implement these pricing systems or to implement sufficiently stringent pricing systems. And by doing so, they would fail to reduce greenhouse gas emissions across Canada. So to address this mischief of them potentially failing to reduce greenhouse gas emissions, this act is going to establish minimum national standards that apply across Canada, setting a pricing floor across the whole country. So Canada produced evidence that shows that meeting these minimum national standards of greenhouse gas price tendency is of sufficient concern to Canada as a whole that it's a national concern. And the history of efforts to address climate change in Canada shows that addressing climate change in Canada is very important, and that carbon pricing is very important. So it's not for the court to judge whether it's the right way to do it or not. There is also broad consensus among expert international bodies that carbon pricing is the way to reduce greenhouse gas emissions. This matter is critical to our response to an existential threat to human life in Canada and around the world. And so because of this, it passes the threshold test and is a possible matter of national concern. So moving on through the analysis, they say the provinces acting alone or together are incapable of establishing these minimal national standards because if one province chooses not to, or if one of them doesn't have a stringent enough one, then the whole thing fails. And so that affects everybody else in Canada when one province fails to charge for the carbon emissions. Okay, so the withdrawal of one province from the scheme would clearly threaten its success for two reasons. The emissions reductions are limited to only the few provinces that did go through it, and if they don't do it strong enough, then then it won't be good enough. And then third, if that does happen, then that could affect the provinces around them. So that is valid logic at the very least, if you assume that the premise is true, that greenhouse gases can actually be reduced by these prices, by these pricing floors. Okay, so it's well established that climate change is causing the issue. That's certain, and it is causing harm, and so that's why this is such a big issue. So I guess really the question is in the premise. So this was held to be constitutional under Peace, Order, and Good Government, Section 91. Two separate dissents in this case. So dissent number 1, rather than establishing the minimum national standards, part 2 empowers the executive branch to actually change these standards on an industry by industry basis after the fact. And so he can do this at any time. He can say these individuals and these industries now need to pay more, pay less, and this judge says that has no boundaries. Therefore, it's it doesn't. This is a matter of legislator to create rules that change, but even more so, there's a rule of law concern here for an executive to be able to modify the law without even a record of it. So very serious concern there. But, and then the second dissent, that in this dissent, he said this was entirely unconstitutional and not supported by any source of federal authority. That first of all, this subject matter falls squarely within provincial jurisdiction, and that its premise to have giving them all the same authority is fatal to the constitutionality of the act under Parliament's residual authority to legislate with respect to POG. So basically, he was also saying here that this act was just it confers permanent power to the executive branch, and it didn't make logical sense. Neither of these took a look at the premise, which I thought was interesting. I mean, they're finding actual rule-based dissents here, instead of saying, are we so certain that these pricing floors and pricing stringency standards will have a positive effect on greenhouse gases? I don't think that was literally proven personally. That's just my personal opinion. Okay, a couple notes on this case. The pith and substance of a statute or a provision must be identified without regard to the heads of legislative competence. So it's a matter of order. First, you determine the pith and substance, then you identify the head of power that it falls under, not mixing those two together. And then the effect of finding that a matter is one of national concern is permanent and confers exclusive jurisdiction over that matter. However, the scope of that power is then defined by the nature of the concern itself, the national concern, and only aspects with a sufficient connection to the underlying inherent national concern will fall within the scope of the federal power. Okay, so that concludes Section 5. Best of luck on your NCA exams. Please, if you got value out of this video, smash that like button, comment, subscribe.